Have you ever been arrested? Hi, I'm Simon Dippenaar and I'm an attorney. If you have been arrested, you are probably familiar with criminal proceedings and your rights as an accused individual. But if you've never been arrested, and I hope that remains the case, it's worth knowing what to expect. If you make a mistake and find yourself on the wrong side of the law, it's important to know your rights so you know if they are upheld or disregarded. Section 35 of our Constitution serves as a fundamental safeguard for the rights of individuals who have either been arrested, detained, or accused of criminal offences. Now, this section addresses your rights from the moment of your arrest throughout your criminal trial, ensuring fairness and protection under the law. If you are accused of a crime, you have certain essential rights that guarantee you a fair trial. You are presumed innocent until proven guilty. You have the right to be informed of the charges against you. You have the right to legal representation, either through your own lawyer or one provided by the state if you cannot afford it. You have the right to adequate time to prepare your defense. You have the right to a public trial. You have the right to avoid self-incrimination. You also have the right to call and challenge witnesses. You have the right to trial proceedings in a language you understand or with the assistance of interpreter if needed. You have the right to be protected from retroactive criminalization. In other words, you cannot be punished for an act that was not criminal when you committed it, even if the law has since changed. You have the right to timely sentencing if convicted. You have the right to appeal both conviction and sentence. These rights are enshrined in the Criminal Procedure Act. This is a fundamental piece of legislation governing criminal proceedings in South Africa, which ensures they are conducted in a fair and transparent manner. It sets out the procedures to be followed in the investigation, arrest, prosecution, and trial of the criminal cases in the country. The Act safeguards the rights of accused persons and sees that justice is served. Now, if you are arrested and detained by the South African Police Service, you should be brought before a court of law within 48 hours, excluding weekends. Now, during the initial court appearance, the charges are presented and you can apply for bail. However, bail is not guaranteed and may be denied if the court thinks you are a risk to the public or a flight risk. There are three types of bail application. Police bail, you can apply for bail at the police station within 48 hours of your arrest if the offence does not fall under Part 2 or Part 3 of the Schedule 2 offences. In other words, you can apply for bail if you have committed an offence which is not considered serious, such as theft under 2,500 Rand, common assault, or exceeding a speed limit. Then prosecutor bail. The Director of Public Prosecution or authorised prosecutor may sanction your release on bail before your first court appearance if you are charged with a Schedule 7 offence. Now, these offences are slightly more serious. For example, culpable homicide, assault, grievous bodily harm, robbery, theft, possession of drugs, and fraud, where the amount involved does not exceed 20,000 Rand. Bail applications in court. Now, if you are charged with a Schedule 5 or 6 offence, a formal bail application will need to be made in court. It may be made by affidavit or by calling you or a witness to the stand. You will need to inform the court of any pending cases or previous convictions at the bail hearing, and the prosecutor may state why bail should not be granted. The court will take various factors into account before making a decision and may postpone the application in order to make a decision. Any postponement should not be longer than 7 days. To deny you bail, the court will have to prove or need to prove on a balance of probabilities that your release will endanger your own safety, the safety of the public, or any other particular person. You will avoid your trial. You will attempt to influence or intimidate witnesses or hide or destroy evidence. You will undermine or endanger the functioning of the justice system. You will disturb public order or undermine public peace and safety. Now, where the magistrate holds any of the above to be a risk, bail will be refused. The amount of bail is set at a rate that will make sure you return to court to finalize the matter, because bail is refundable even if you are found guilty. If you cannot afford bail, you can argue for a reduction. Alternatively, you'll be held in custody until your trial is finalized. This is what is meant by being held on remand. If you are arrested, I strongly advise you to enlist the services of a skilled bail attorney such as our firm SDLAW. Being arrested and charged is a stressful situation. You may be agitated or confused. Your lawyer will ensure you have the best chance of securing bail and may be able to negotiate a reduction in the fee if you need it. If you have questions about criminal law, if you need a criminal defense lawyer right now, contact me on the number below.